criminal defense lawyer Ryan Pacyga, and today I'm going to continue in my series on federal court cases. So what I'm going to talk about today is a federal motion hearing and what that means. And that is that after somebody's been indicted or charged with a federal crime and they've made their initial appearance in court and it's determined whether or not they're out on a signature bond or whether they're in custody for the whole case, at some point during the case there will most likely be a motion hearing, and that's under Rule 12 of the Federal Rules of Civil or Criminal Procedure. And what a motion hearing is about is really two things. One category that we talk about typically is discovery, which means the evidence in the case, and the other category is suppression, which means knocking evidence out in the case. And sometimes that means that the whole case is thrown out if you win on that suppression hearing, and other times it means just certain pieces of evidence are not admissible if the case goes to trial. So let's talk about the discovery first. Typically when I defend a federal criminal case, we'll file a lot of motions asking for additional discovery, and discovery is evidence in the case. So we want things like whether or not the government was having anybody electronically or otherwise monitor our defendant before they charge the case out. So things like wiretaps, things like phone GPS, phone pinging, all of those sorts of things. Any video recording they were doing, if they were doing undercover operations, or audio recordings and things like that. We'll also ask for evidence about any other prior bad acts that they know about our client that maybe they're not charged with in the federal case, but that the government might intend to bring out in testimony if the case goes to trial. So maybe John is on trial for a drugs and gun case, and that's what he's been indicted for, but the government also knows that previously he was involved in a theft, and they're not charging him with theft, but they want to be able to bring that up in the trial, that he's known to commit thefts in the area, or that there's evidence of that. That's additional information that we want to bring as a motion and saying, if you know about that and you intend to do that, let us know about it early so that we can prepare to defend against this or to argue why it shouldn't come into evidence. There are things called Brady material, which is exculpatory evidence. That is stuff that can help negate our client's guilt at a trial. So not only bad things that the government might know about our client, but also good things that might tend to convince a jury or help a jury find the person not guilty. We want that evidence as well. Giglio material is another, and then Jenks Act. Jenks Act is information that they have in the form of statements or other reports that they might not introduce into evidence that are something about going on in the case, and we want copies of those things, because just because the government doesn't want to use that evidence to prosecute someone does not mean that that evidence couldn't be useful for the defense in the trial. So we want that information as well. So that's the first kind of category, this discovery motions that we file, and the idea is sometimes the federal rules say that the government, the prosecutors, do not have to give this evidence any time prior to when a witness testifies in the trial. So we could be in day 4 of the trial, Susie could come to the stand and testify how bad the defendant is, and then she said something a little different than what she told investigators a month ago, but we don't get copies of that. And the government that night will give us copies, and we have to all of a sudden scramble through 100 to 500 pages of reports that we've never been able to see before, and somehow have to be able to deal with that the next morning in front of a jury. So we ask instead that the judge order the government to turn that stuff over early so we have enough time to know what's coming and know how to respond to it, so that we're not delayed in front of a jury, or so that we're not missing points that we can raise in our client's defense. So that's that first category of stuff, and we want to ask for it early enough so that we can do a good job in the trial of the case, and it can help for settlement negotiations and help gain a more favorable offer for the defendant if the defense has some good information that the government is ordered to produce that they haven't already produced. The second category on these motions hearings is what's called suppression, and oftentimes that involves somebody testifying. I just finished a federal hearing today, for example, where an officer who was one of the head agents on the case testified, and we're trying to get our client's statement thrown out of evidence. And so these involve things like I just said, there's a statement that the defendant made that was not Mirandized, and we allege that that violated the Miranda rule, that they should have been given the Miranda rule warning before they made this statement that hurts their case. Sometimes that means we'll argue about whether there was a lawful traffic stop or whether there was probable cause to even arrest a person. Other times we'll argue that there was an illegal warrantless search and that the search should have had a search warrant, and because of that the evidence that they found without a warrant should be thrown out of evidence. Sometimes there was a warrant, but we'll argue that the warrant wasn't proper, either because there was bad information given to the judge who issued a warrant, or because even with the information, if it's correct, that was given to a judge, wasn't enough information to really deserve a warrant in a case, and then a warrant can be thrown out for that as well. So those are suppression arguments that come up in motion hearings as well. Not every federal case has a suppression hearing. Most, if not all of them, at least there's a fight about the discovery, but that's what a motion hearing is about. After the testimony happens in a case, if there's a suppression part of the motion hearing, then usually the magistrate has that hearing and they want us to brief it, which means make written arguments. So we'll order a transcript, we'll get a copy of that, we'll make our written arguments about why the evidence should be thrown out or why the whole case should be thrown out. And the government makes their brief, their written argument, and then the magistrate reads through both sides of the argument and then issues what's called a report and recommendation, or it's often called an R&R. And then once the magistrate issues the report and recommendation, either side has an ability to object to that, and then it's reviewed by the actual, what's called Article 3 judge, the main judge in the federal criminal case. So if I ask a judge to throw out evidence because there was a warrantless search at my client's home and the judge disagrees and keeps the evidence in and writes that in the report and recommendation, we can object to that report and recommendation and ask the actual Article 3 judge to review that R&R and overturn it, hopefully. So that's what these federal motion hearings are about. They often involve Rules 12 and Rule 16, which is the discovery rule from the Federal Rules of Criminal Procedure. If you have more questions about federal cases, I defend federal cases around the nation. My name is Ryan Pacyga. You can find us at arrestedminnesota.com or at 612-339-5844.